I'm Paul McConnell of the Dr. Lawyer team, and I'm going to talk to you about caps on damages or limits on compensation under the Federal Tort Claims Act. The short answer is that state tort law damage caps do apply in every case. The Federal Tort Claims Act is a federal law and has very specific federal procedures for the administrative process and the litigation process. We talk about a number of these processes in other videos. That said, under the FTCA, the state's tort law applies. That is, if the act giving rise to the injury occurred, for example, in the state of California, then the federal court will apply California tort law and the claimant will be subject to California damage caps. Some states put caps on damages awarded by juries in tort or personal injury cases. A cap is a law that puts an arbitrary ceiling on the amount of damages that a judge or a jury can award in a case, regardless of the facts or evidence presented in a specific case. The types and amounts of caps vary by state and can be imposed on parts or all aspects of an award, including compensation for actual medical costs, loss of earnings, pain and suffering, economic damages. First, not every state has a cap on damages, and at the other end of the spectrum is Nebraska, for example, that has a cap on all types of damages. That said, most of the states focus on pain and suffering and do not limit recovery for economic damages. Thus, if a state has a cap of $250,000 for non-economic damages, a client can, in some circumstances, still recover more and sometimes much more. For example, if an injury required lifetime care or impacted a victim's ability to work, those would be economic damages that we could prove. Most of the largest settlements under the FTCA have a direct correlation to economic damages, sometimes in the tens of millions of dollars. If you've been injured on account of the acts of a federal employee, call us for a free consultation. We're built different. Join the team.